Hi, thanks very much for giving me the chance to speak to you today. My name is Stuart Hargreaves, and I'm an associate professor in the Faculty of Law at the Chinese University of Hong Kong. The latter half of 2019, as I'm sure you all know, saw a sustained period of civil unrest in Hong Kong, and so today I'm going to briefly go over some of the legal aspects to it. In February of last year, the Hong Kong government proposed amending the Fugitive Offenders Ordinance to allow the extradition of criminal suspects to jurisdictions with which Hong Kong did not have a separate extradition treaty. The proposal would have allowed the chief executive, Hong Kong's leader, Carrie Lam, to approve such extraditions on a case-by-case basis, providing that certain safeguards were met. The safeguards included things like the crimes being of a certain type, that there was some evidence provided to a court in Hong Kong that they had in fact been committed, and so on. However, because the proposed amendments would have applied to extraditions to any jurisdiction with which Hong Kong did not have a formal extradition treaty, this included mainland China. And here, of course, is where the troubles began. Many Hong Kongers were worried that the amendments could or would be used by the central authorities to go after its political opponents in Hong Kong. The safeguards were of little value, they said, because they had no faith in the ability of the chief executive to resist political pressure from the mainland to extradite suspects, since she was dependent upon Beijing for her position. So this sparked widespread protests, the scale of which was staggering. One protest numbered 2 million people. Now bear in mind that the entire population of Hong Kong is only about 7 million people. Weekly clashes occurred throughout the summer and into the autumn, with the typical pattern being a largely peaceful march on a Sunday afternoon, followed by much more violent clashes between what were described as the frontline protesters and the police after the majority of protesters had gone home. In early September, the bill was formally withdrawn, but by now the protesters had settled on what they called the 5 demands, not one less formulation, and so the weekly clashes continued. In October then, we got to the next interesting legal phase of the situation. The government relied on a colonial-era law known as the Emergency Regulations Ordinance. That law was initially written in the 1920s to aid the governor in dealing with what was basically a port workers' labor dispute, and it allowed the governor, and now the chief executive, to essentially make any order they felt necessary in a time of, quote, public danger or emergency. So, declaring Hong Kong to be facing an ongoing public danger as a result of the protests, the chief executive relied on this ordinance to ban the wearing of masks at public assemblies. This was formerly known as the Prohibition on Face Covering Regulation, but popularly known as the Antimass Law. Anyone convicted could be punished by up to a year in prison. Now, the regulation was immediately challenged in court as an infringement of Hong Kongers' rights to assembly and expression, and by November was declared unconstitutional by the courts of first instance, unusually sitting as a two-person bench, perhaps to indicate the importance of the matter. Now, the court found that while the concept of a mask ban was not necessarily automatically unconstitutional, as adopted, the regulation was far more than was necessary to achieve the legitimate aims of deterring violence at protests. For instance, it sought to criminalize the wearing of masks at all public assemblies, whether or not they were authorized, peaceful, and so on. It also applied in part beyond assemblies entirely. It gave the police the power to force an individual wearing any face cover in any public place, even if they're alone, to remove it in order to allow an identity check to be made. The court also found that reliance on the ground of public danger to activate the emergency powers was unconstitutional because it allowed the chief executive to entirely bypass the Legislative Council on very vague grounds, contrary to the principle of the separation of powers. Now, at this point, the ruling is under appeal, but a decision is expected within the month. But I think what's really important for the future of Hong Kong's constitutional structure with this case is actually less the outcome of the appeal itself, but what China does in response if the appeal upholds the initial finding of unconstitutionality. The central authorities were furious with the initial decision, and a spokesperson for the Standing Committee of the National People's Congress stated that only they had the right to perform constitutional interpretation inside Hong Kong. Now, it's true that the Standing Committee does have the right to interpret Hong Kong's basic law, its mini-constitution or quasi-constitution, and those interpretations do bind the local courts. But the local courts have also regularly performed all kinds of constitutional interpretation since 1997. So that statement was rather alarming. Now, Beijing has in fact since backed away from that language, but it certainly remains possible that the Standing Committee could interpret the Basic Law in a way to ensure that the Antimass Law survives, regardless of what the local courts say. Now, although it possesses the power of final interpretation of the Basic Law, the Standing Committee is nothing like a common law apex court. It's a political body, only about a quarter of whom have any kind of legal training. Under the principle of one country, two systems, then, the Standing Committee has used this power quite sparingly, only 5 times since 1997. However, its most recent use was in 2016 and was a nakedly political interpretation that served effectively to prevent certain legislative councillors from taking their seats to which they had been duly elected. Now, should the Standing Committee use this power again to correct what it sees as a very unhelpful decision from the local courts, then I think it once again will serve as a signal that the firewall between the two systems, at least the two legal systems, is substantially weakening. The protests have now largely ended thanks to the new crisis of the coronavirus. The hits keep on coming for Hong Kong this year. But I think once the medical crisis is passed, it's a near certainty that the political and legal crisis will almost certainly return. Thank you for your time.